She was standing on her porch in a bathrobe when the moving trucks pulled in. By 8:12 a.m., she'd called 911. Two deputies arrived, checked my ID, checked the deed, then looked at the woman who'd made the call. "Ma'am, according to this document, the land at your address is owned by this gentleman. Her name was Diane Marsh, HOA president of Clearwater Cove, Georgia. 9 years in that community, 6 years running it. She had no idea who I was. She saw two moving trucks at a house vacant for 2 years and assumed trespassing. She didn't check the county records. She didn't knock on the door. She called the sheriff on a black man moving into his own home. What Diane never bothered to learn in 6 years as HOA president is that I don't just own that house. I own all 340 acres of Clearwater Cove, every road, the lake, the clubhouse, the ground beneath all 89 homes, the ground beneath her home. I bought the master deed in 2021 for $19 million. 4 years as a quiet ground lesser, restoring the original developer's mansion while she ran the community I owned. That morning, I handed the deputy the master deed and let him explain it to her. Then I went inside and started unpacking. By February, Diane had been indicted on criminal fraud charges, lost her real estate license, had her mortgage called, and sold her house for $185,000, a house she'd paid $410,000 for, after I terminated her ground lease for material breach. She walked out of Clearwater Cove with $8,000 and a court date. My grandfather lost his land in Georgia in 1974. The bank called his loan. The system looked the other way. I spent 30 years making sure that would never happen to me. Diane Marsh found out what that preparation looks like. Quick question before we begin. Where are you tuning in from today? And don't forget to like and subscribe for more stories like this. The moving trucks arrived at 7:45 a.m., 2 of them, a full-service crew out of Atlanta, 8 men who knew their work and moved with the quiet efficiency of people who'd done this 1,000 times. They pulled into the circular driveway at 1 Clearwater Drive, killed their engines, and began the familiar choreography of ramps and dollies and carefully wrapped furniture. It was a Saturday morning in September 2025, the kind of Georgia morning that reminded you why people built lake houses. Cool air carrying the smell of pine and water, the lake visible through the tree line in long broken flashes of silver light, the sky overhead, the particular blue that only exists in the south in early fall. I stood in my driveway and breathed it in. 2 years of renovation, 2 years of weekends driving down from Atlanta, walking the property with contractors, making decisions about original heart pine flooring and period-accurate window hardware, and the exact shade of white for the wraparound porch. 2 years of watching a house that had been neglected for a decade slowly become what it was always meant to be. It was done now, and I was home. I'd been planning this moment since 2021, when I'd purchased the Clearwater Cove Master Deed through Webb Land Trust LLC for $19 million. The acquisition had taken 11 months to close, a complicated transaction involving the Whitfield family estate, 4 different attorneys, and enough title work to fill 2 bankers' boxes. But the result was clean and absolute. Webb Land Trust LLC owned all 340 acres of Clearwater Cove, every road, every common area, the lake access strip, the HOA clubhouse parcel, and the land beneath all 89 residential structures in the development, including the land beneath the house across the cul-de-sac, a neat colonial with a perfectly maintained garden, where a woman in a pale blue bathrobe was standing on her porch, watching my moving trucks with an expression I recognized immediately. Not curiosity, not the neighborly interest of someone watching a new resident arrive. Suspicion. Her name was Diane Marsh. I knew who she was. I'd reviewed the HOA records thoroughly when I purchased the development. Diane had been HOA president since 2019, retired school teacher, ran the association with, by all accounts, absolute authority. She didn't know who I was. She saw 2 moving trucks pulling into a house that had been vacant for 2 years. She saw men carrying boxes through a door that had been locked since before she'd become HOA president. And she did what Diane Marsh apparently always did when she saw something in Clearwater Cove that she hadn't authorized. She went inside and made a phone call. I was directing the crew on placement of the living room furniture when I heard the cruiser. Harmon County Sheriff's Department, 2 deputies. They pulled in behind the second moving truck at 8:12 a.m., and stepped out with the careful, neutral posture of officers responding to a call they haven't fully assessed yet. The older deputy, early 40s, broad-shouldered, name tag reading Deputy T. Warren, approached me directly. "Good morning, sir. We received a call about a possible breaking and entering at this address. Can I ask what's going on here?" "Good morning, deputy. I'm moving in. This is my home." He looked at the moving trucks, the crew, the open front door. "Can I see some identification and proof of ownership?" "Of course." I went to my car, a 7-year-old Volvo that I'd driven down from Atlanta that morning, packed with the things I hadn't trusted to the moving crew, and retrieved my Georgia driver's license and the property deed from the glove compartment. I handed both to Deputy Warren. He reviewed them carefully. His partner, a younger deputy whose name tag read Deputy K. Ellis, stood slightly back, watching the scene. "Sir, this property is titled to Webb Land Trust, LLC. "That's correct. I'm Marcus Webb. I'm the sole trustee and beneficiary of Webb Land Trust, LLC. I handed him a third document, a 1-page certification from the trust showing my identity as trustee. "This is my home." Deputy Warren was still reviewing the documents when I heard footsteps on the driveway. Diane Marsh had come across the cul-de-sac. She'd changed out of the bathrobe. She was dressed now, pressed slacks, a collared shirt, the bearing of a woman who considered herself the authority in any room she entered. "Deputy, I'm Diane Marsh. I'm the president of the Clearwater Cove Community Association. I called this in." She looked at me briefly, then back at the deputy. "That property has been vacant for over 2 years. The previous owner abandoned it. These people showed up this morning without any notice to the community." Deputy Warren looked at her. "Ma'am, this gentleman has a deed to the property." "How do I know that deed is real? Anyone can produce a document. That house has been empty since 2023. Nobody from Webb Land Trust has ever introduced themselves to this community or attended a single HOA meeting." The deputy looked at me. I looked at Diane. There was a specific kind of challenge in her voice. The challenge of someone accustomed to being the person who defined what was legitimate in a given space. I recognized it. I'd spent my career in rooms where people used that voice on me and expected it to work. It had worked on me exactly 0 times. "Deputy Warren," I said calmly, "would you give me 1 moment?" I went back to my car. In the passenger seat, in a manila folder I'd placed there specifically for this day, was the document I'd been carrying with me every time I visited this property for 4 years. The master deed. Webb Land Trust, LLC's complete ownership record for all 340 acres of Clearwater Cove. Every parcel, every road corridor, every common area, every residential lot. 87 pages, recorded with Harmon County in October 2021. I walked back to Deputy Warren and handed it to him. He took it with the expression of a man who'd been handed something heavier than he expected. He opened to the first page, then the second. He flipped through several more. His partner, Deputy Ellis, moved closer and looked over his shoulder. Deputy Warren's reading slowed. He looked at the parcel map on page 12, the one showing the full 340-acre boundary, with every lot clearly delineated inside it. All of them labeled Webb Land Trust, LLC, fee simple owner. He looked up at Diane. "Ma'am, are you a homeowner in this development?" "Yes, I live at 4 Clearwater Drive. I've lived there for 9 years. According to this document," he held up the master deed, "the land at 4 Clearwater Drive is owned by Webb Land Trust, LLC." He paused. "By this gentleman." Diane looked at the document, then at me. Something moved across her face. It wasn't understanding yet, not fully. It was the early edge of it. The moment before comprehension arrives, when a person senses that the ground beneath their certainty is less solid than they believed. "That's not possible," she said. "I own my home." "You own your structure," I said. "The land it sits on is mine." That's been true since 1968, when Harold Whitfield built this development. It was true when you purchased your home. It was true when you were elected HOA president. And it's true this morning when you called 911 on the man who owns the ground beneath your feet. The cul-de-sac was very quiet. One of the moving crew had paused in the doorway, a wrapped lamp under his arm, watching the scene. Deputy Warren looked between us. "Sir, do you have any additional documentation establishing your identity as trustee, just for our report?" "Of course." I handed him the trust certification and a business card. Marcus Webb, attorney at law, Webb and Okafor Commercial Real Estate, Atlanta. He looked at the card, then at Diane, then back at me. Sir, everything appears to be in order. I apologize for the inconvenience. No apology necessary, Deputy. You were doing your job. You responded to a call and verified the facts. That's exactly right. Deputy Ellis was already writing something in his notepad. Deputy Warren handed my documents back, gave Diane a careful look that communicated without words that he had questions about the nature of the call she'd made, and walked back toward the cruiser. Diane stood in my driveway. She was still processing. I could see it in her face, the recalculation happening in real time. 4 years as HOA president, 9 years as a homeowner, 9 years of believing she lived in a community where she understood the power structure. And now this. This is, she started. Ms. Marsh. My voice was even, not hostile, not warm, precise. I've owned this development for 4 years. I've been a quiet ground lesser. I've maintained the common areas, kept the roads in good condition, and asked nothing from this community beyond what the lease agreements require. I've been patient. I look toward the lake. In the past 2 years, while I've been renovating this house, things have happened on my property that we're going to need to discuss. Structures built without my permission, fees collected for use of my private road, community funds spent on improvements that don't appear to have benefited the community. I turned back to her. I suggest you call your HOA attorney, Ms. Marsh, today, if possible. And I strongly suggest you do it before Monday. I handed her a business card, the same card I'd given Deputy Warren. She took it without speaking. I walked back into my house. Behind me, I heard her footsteps on the driveway. Then, silence. The moving crew resumed their work. The lake light shifted through the trees. Someone carried my father's old reading chair through the front door, and it felt, for a moment, like something being returned to where it belonged. I stood in the center of my living room. Original heart pine floors restored to a warm gold, wraparound porch visible through the French doors, the lake beyond it, and let the morning settle around me. My grandfather had owned 40 acres of farmland outside Valdosta, Georgia. He'd lost it in 1974, a combination of predatory lending, a bank that called a loan at the worst possible moment, and a legal system that hadn't been particularly interested in protecting the land rights of black farmers in rural Georgia. My father had told me the story every year of my childhood, not bitterly, matter-of-factly. The way you tell a child about weather, this is how things work, this is what the world does, and this is why you prepare. I'd prepared. 25 years of real estate law, 30 years of building a land portfolio, 11 months closing the Clearwater Cove acquisition, 4 years of patient ground lease income while I restored the house that was now mine, in every sense of the word. Diane Marsh had called 911 on a man she assumed was trespassing. She didn't know he was the ground lesser for every home in Clearwater Cove. She didn't know he'd been watching what her HOA had been doing to his property for 2 years. And she definitely didn't know that the call she made that Saturday morning was the last mistake she'd ever make as HOA president. I spent the first week in my lake house the way I spent the first week of every property acquisition. Walking, photographing, documenting. I'd done it in 2021 when I first took ownership of Clearwater Cove, a methodical survey of all 340 acres, every road, every common area, every structure on my land. I had that baseline documented in files going back 4 years. Now I walked it again, same route, same systematic approach. But this time, I was looking for differences. What had changed in 4 years of Diane Marsh's HOA presidency? What was on my land now that hadn't been there before? I found the first violation on day 2. The lake access road ran from the main development entrance down to the waterfront, a quarter-mile gravel road that connected Clearwater Cove's residential streets to the private lake shore. It was my road, deeded to Webb Land Trust in the original 1968 development documents as part of the master parcel. At the bottom of that road, where it widened into the lake access area, there was a structure, a large one, a boat storage facility, metal framing, corrugated steel roof, concrete floor, 12 individual boat slips with roller doors. Well built, professional construction. A sign on the front read, Clearwater Cove Community Boat Storage, HOA, members only. I walked around it twice. Then I pulled out my phone and began photographing. Wide shots, medium shots, close-ups of the construction, the foundation footprint, the concrete pad extending across my lake access land, the electrical connection running from the facility to the HOA's utility hookup, GPS coordinates, date stamp, time stamp. I checked my records. In my 2021 survey documentation, this spot had been open gravel, no structure, no foundation, no concrete. The boat storage facility had been built after my purchase, on my land, without my knowledge or permission. I called my construction contact in Atlanta that afternoon, a contractor named Roy Simmons, who'd done work for me for 15 years. Roy, I'm sending you photographs of a structure on my property. Boat storage, metal frame, concrete floor, 12 slips. Can you give me a replacement cost estimate? Roy called back the next morning. Marcus, that's a solid build. Whoever put it up didn't cut corners. Replacement cost at current prices, I'd put it at $85,000 to $90,000. Done without permits, done without the landowner's permission, done on someone else's property. Then it's also an unpermitted structure. Harmon County will have no record of a building permit for that address. I'm going to verify that. I filed a records request with Harmon County Building and Zoning that afternoon. Response came back in 48 hours. No building permit had been issued for any structure at the Lake Access Road address. The boat storage facility had been built on my land, without permits, without my permission, and without any legal authorization whatsoever. I found the second violation on day 3. Going through the HOA's publicly available financial statements, Georgia law requires HOA financial records to be available to any party with a legitimate interest, and as ground lessor I had clear standing. I found a line item that appeared in every annual budget going back to 2022. Lake access fee revenue, $400 per household annually. 89 households, $400 each, every year since 2022. $35,600 per year, 3 years running. $106,800 total, collected by the HOA for lake access. The lake access road was my private road. The lake access area was my private property. The HOA had been charging its residents annual fees for the right to use land they had no authority to monetize. They were collecting money for access to my property and depositing it into their own accounts. I documented the line items, cross-referenced them against the HOA's bank records, which were also available through Georgia Open Records. The deposits were there, regular, quarterly, clearly labeled. $106,800 collected from 89 homeowners for access to my private road and lake frontage. Not 1 cent of it had ever been offered to me. I found the third violation on day 4, and this one was worse than the other 2 combined. The HOA had instituted what they called a Community Improvement Assessment in 2022, $672 per household per year, collected quarterly, described in HOA communications as funding community-wide infrastructure and beautification projects. 89 households, $672 per year, 3 years, $179,424, nearly $180,000. I pulled the expenditure records. The first thing I noticed was what wasn't there. No road resurfacing, no common area landscaping, no lighting upgrades, no lake access improvements. None of the things you'd expect to see from a $180,000 community improvement fund. What was there? $43,200. Landscape services, 4 Clearwater Drive. Diane's address. $31,800. Hardscape and driveway improvement, 4 Clearwater Drive. $18,400. Dock construction and installation, 4 Clearwater Drive. On my lake access land. $22,100. Landscape services, 7 Clearwater Drive. Board member Sandra Cole's address. $19,600. Fence installation and landscaping, 12 Clearwater Drive. Board member Robert Nix's address. $16,200. Exterior renovation, 19 Clearwater Drive. Board member Gary Tillman's address. The remaining $28,124 was distributed across various cash withdrawals and vendor payments to companies that, when I searched Georgia business records, didn't appear to exist. Diane Marsh had collected $180,000 from 89 families for community improvements. She'd spent $113,100 of it on her own property and the properties of her 3 allied board members. She'd spent $28,124 on payments to shell vendors. She'd spent $12,000 on actual community improvements, a new mailbox cluster and 2 benches near the entrance. Total percentage spent on the community it was collected from, 6.7%. I sat with that number for a long time. I'd seen HOA fraud before. In 30 years of real estate law, I'd encountered misappropriation, self-dealing, sloppy accounting that crossed into theft. I'd seen it in developments I'd represented as counsel and in developments I'd owned. But this was brazen, genuinely, categorically brazen. Diane had been collecting money from her neighbors, families who trusted her, who voted for her, who believed she was managing their community in good faith, and spending it on her own landscaping, on her own driveway, on a dock on my land. I photographed every page of every financial record. Then I called James. James Okafor was my law partner in Atlanta. We'd practiced together for 16 years. He handled litigation, I handled transactions. Between us, we'd covered almost every angle of commercial real estate law in Georgia. James, I need you to file a formal demand on the Clearwater Cove HOA. I walked him through everything. The boat storage facility, $85,000 structure built without permits on my land. The lake access fees, $106,800 collected for use of my private road. The Community Improvement Fund, $180,000 collected, $168,000 misappropriated. James was quiet for a long moment. Marcus, the Improvement Fund situation, that's not a civil matter, that's criminal fraud. I know. You want me to copy the Georgia AG's Consumer Protection Office on the demand? Not yet. I want to see how Diane responds first. Give her the opportunity to understand what she's facing before I bring in the state. You're being generous. I'm being strategic. If she acknowledges and cooperates, the path forward is faster. If she fights it, the AG investigation becomes the appropriate next step. James filed the formal demand letter on September 12th, 6 days after moving day. Diane called me the following morning. Mr. Webb. Her voice was different from the driveway confrontation, controlled, careful, the voice of someone who'd spent a week consulting attorneys and preparing for this conversation. I think we got off on the wrong foot last Saturday. I'd like to meet, clear the air. I'm available Thursday at 2. The clubhouse works. She paused. The clubhouse, of course, was on my land, but she didn't say that. Thursday at 2 is fine. The Clearwater Cove HOA clubhouse was a well-maintained building, original 1970s construction, updated over the years, sitting on a half-acre parcel at the development center. It had a conference room, a small kitchen, and a covered patio facing a manicured common area, all of it on my land. Diane was already there when I arrived. She'd brought her HOA vice president, a man named Carl Briggs, who sat slightly behind her and said nothing for the entire meeting. On the table in front of her was a single legal pad and a pen. Mr. Webb? She gestured to the chair across from her. I sat. I'd brought a briefcase. I set it on the table but didn't open it yet. Thank you for agreeing to meet, Diane said. I want to start by saying, what happened last Saturday was a misunderstanding. The property had been vacant for 2 years. We had no way of knowing you were planning to move in. We were simply watching out for the community. By calling 911, by responding to what appeared to be an unusual situation. I looked at her steadily. Ms. Marsh, I didn't come here to relitigate Saturday. I came here to discuss 3 specific issues with my property that my attorney has already outlined in his demand letter. We received the letter. Our position is that the board acted within its authority on all 3 items. Walk me through that position. She straightened slightly. The boat storage facility was built on what we understood to be community common land. The lake access fees are for maintenance of the access road, which the community has used for 50 years. And the community improvement assessments were authorized by the board and spent on legitimate community expenses. I let her finish. Then I reached into my briefcase and produced 3 folders. The first folder, photographs of the boat storage facility, my 2021 survey documentation showing the land was clear, the Harmon County permit search showing no permits issued, and the Webb Land Trust deed confirming ownership of the parcel. You built an $85,000 permanent structure on my land without my permission, without county permits, and without any legal authorization. That's trespassing and unauthorized construction. Diane looked at the photographs. We understood that land to be mine. It's been mine since 2021. It was the prior developers since 1968. It has never been community-owned. The common areas in this development are ground lease parcels. I own the land, the HOA manages the use. Building a permanent structure on a ground lease parcel requires the ground lessor's written permission. You don't have it because you never asked for it. I opened the second folder. The lake access road is my private property. It has been since the original development documents in 1968. The HOA has been charging residents $400 per year for access to my private road and collecting that money into HOA accounts without my knowledge or consent. That's $106,800 collected over 3 years for use of my private property. Diane. The road maintenance has been performed by my property management company, not the HOA. You collected fees for maintaining a road you didn't maintain on land you don't own. I opened the third folder. 3 years of HOA financial records, every expenditure line item. Highlighted in yellow, every payment to an address in Clearwater Cove. Red circles, every payment to Diane's address. You collected $179,424 from 89 homeowners for community improvements. You spent $113,100 of that on your own property and the properties of 3 board members. You spent $28,000 on vendors who don't appear to exist in Georgia business records. You spent $12,000 on actual community improvements. Diane looked at the records. The color in her face changed. Not dramatically, she was too controlled for that. But the specific quality of her certainty shifted. The careful preparation she'd brought to this meeting was encountering something it hadn't fully prepared for. Those were authorized community improvements, authorized by you. Spent on your property, funded by your neighbors. I kept my voice level. Ms. Marsh, $43,000 of your neighbor's money went to landscape your yard. $18,000 went to build you a dock on my land. You can't prove that the expenditures were improper. I don't need to prove it. I slid the folder across the table. The records prove it. These are your HOA's own financial documents, obtained through Georgia Open Records Law. The addresses are in your own accounting entries. The amounts are in your own bank statements. I paused. I've been a real estate attorney for 30 years, Ms. Marsh. I've reviewed thousands of financial records. These are not ambiguous. Diane looked at the folder. Then she looked at me. For the first time since Saturday morning, the authority was completely gone. What remained was something more fundamental, the expression of a person who understood, in this exact moment, that the ground had shifted entirely beneath her. Literally. What do you want? She asked quietly. My attorney's demand letter outlines the specifics. Removal of the boat storage structure at HOA expense. Full accounting and restitution of the lake access fees. Full accounting and restitution of the Community Improvement Fund. I closed my briefcase. And Ms. Marsh, I'd suggest you consult a criminal attorney, not just your HOA counsel. The improvement fund situation goes beyond a civil dispute. I stood. You called 911 on me in my own driveway, I said. I want you to understand something clearly. I've been patient with this development for 4 years. That patience has a limit. You just found it. I walked out of the clubhouse. My clubhouse. On my land. James filed the formal demand on September 12th. 3 pages. Clean. Specific. No ambiguity. Item 1. Immediate cessation of all use of the unauthorized boat storage facility at the lake access road. Full removal of the structure at HOA expense within 60 days. Restoration of the land to its prior condition. Item 2. Full accounting of all lake access fees collected from 2022 through present. Restitution of $106,800 to Webb Land Trust LLC within 30 days. Item 3. Full accounting of the Community Improvement Assessment Fund. Restitution of $167,424. The difference between funds collected and funds demonstrably spent on actual community improvements within 30 days. Total demand, $274,224 plus structure removal costs. Diane's HOA attorney, a man named Frank Delgado out of Savannah, who specialized in community association defense, responded on September 19th, 7 pages, considerably less clean. The response argued that the boat storage facility had been built on land the HOA understood to be common area under community governance, that the lake access fees represented legitimate maintenance cost recovery for a road the community had used for 50 years, that the community improvement assessments had been properly authorized by the board and spent on legitimate community expenses as determined by board discretion. And at the bottom, one line that told me everything I needed to know about Diane's strategy. Our client respectfully declines the demand in its entirety. I called James. She rejected it. I saw. Frank Delgado is a decent HOA attorney, but he's working with a client who built a structure on someone else's land and embezzled $168,000 from her neighbors. There's no legal theory that covers that. She thinks I'm bluffing. Apparently. Then let's stop bluffing. The ground lease review notices went out on September 22nd, 5 of them. Diane Marsh, and 4 board members who had voted to authorize both the boat storage construction and the community improvement assessment structure. Carl Briggs, Sandra Cole, Robert Nix, and Gary Tillman. The notices were precise. Each one cited the specific ground lease agreement for the recipient's property. Each one cited Section 11, Paragraph 2 of the Standard Clearwater Cove ground lease, the material breach provision. Each one identified 2 specific breaches. First, authorizing construction of a permanent structure on ground lessor property without permission. The boat storage facility sat on a parcel deeded to Webb Land Trust. Building on it without the ground lessor's consent was a direct violation of the lease terms governing use of lessor property. Second, collecting and retaining fees for access to ground lessor's private road. The lake access road was Webb Land Trust property. Monetizing access to it without the ground lessor's authorization constituted unauthorized commercial use of leased land, a material breach under Section 11. The notice closed with standard language. This notice does not constitute formal termination. It is a notice of review. Ground lease termination would extinguish your leasehold interest in your residential lot. You are advised to consult with an attorney within 21 days. Diane received hers on the morning of September 23rd. She called James that afternoon. Not me, James. This is harassment. Mr. Webb is retaliating against the HOA for a misunderstanding. James. Mrs. Marsh, the notice is based on documented material breaches of your ground lease. The boat storage facility is on Mr. Webb's land. The lake access fees were collected for use of Mr. Webb's road. These aren't matters of interpretation. We have community rights. Your community rights are defined by your ground lease. The lease does not include the right to build permanent structures on lesser property or collect fees for lesser road access. Your attorney can confirm that. She hung up. Her attorney did confirm it. So did the attorneys for all 4 board members. I heard through James that Frank Delgado had a difficult phone call with Diane on September 25th, in which he explained, apparently at length, that the material breach provision was real, the termination right was legitimate, and that fighting it would accelerate rather than prevent the consequences. Diane's response, according to a board member who later told me the story, was, "He's a corporate landlord trying to bully a community of homeowners. We fight." By September 26th, the notices were no longer confidential. In a community of 89 homes where everyone knew everyone, 5 certified mail envelopes arriving simultaneously at board members' addresses had exactly the half-life of secrecy you'd expect. By noon, the Clearwater Cove Community Facebook group was moving fast. Most of the posts were variations of the same question. What is a ground lease, and why didn't anyone tell us? The answer, which several residents found by simply searching the county property records, was that Webb Land Trust LLC had owned all 340 acres of Clearwater Cove since October 2021. that every homeowner owned their structure but not their land, that this had been disclosed at every real estate transaction through the title process, that most people hadn't read their closing documents carefully enough to understand it. The panic that followed was real and understandable. These were families who'd purchased homes believing they were buying land. The distinction between structure ownership and leasehold interest was not something most people thought about at closing. It was buried in documents, disclosed but not explained, present but not prominent. That wasn't my fault, but it was my responsibility to address. I asked James to post a brief statement in the community group, clarifying that only the 5 board members had received ground lease review notices, that the remaining 84 households were unaffected, that their leases were in good standing. It reduced the panic, but it concentrated the anger. On September 28th, the HOA board called an emergency community meeting. I wasn't invited, but Robert Simmons, a resident who'd introduced himself to me the day after moving day with a handshake and an apology for Saturday's incident, attended and gave me a detailed account. Diane stood at the front of the room. She'd prepared remarks. She was composed, authoritative, the teacher in front of a classroom. She described the situation as a dispute with an aggressive corporate landlord who purchased our community's land through a legal technicality and is now attempting to weaponize that ownership to extract money from hardworking homeowners. The room was quiet while she spoke. Then a woman named Patricia Howard raised her hand. Patricia had lived in Clearwater Cove for 11 years. She was a retired accountant. She had, apparently, spent the 48 hours since learning about the ground lease reviewing her original purchase documents with the precision of someone who'd spent a career reading financial records. Diane, I've reviewed the community improvement assessment expenditures, the ones filed with the county as part of the HOA's annual disclosure. Can you explain why $43,200 of community funds were spent on landscaping at your address? The room shifted. Diane, those were authorized board expenditures for community beautification. At your house? The board determined that improvements to board members' properties contributed to overall community value. Did the community vote on that determination? No clean answer. A man in the third row. Did you know Marcus Webb owned the land when you built the boat storage facility? Diane, we understood that parcel to be community common land. Did you check the county records? We relied on our understanding of the development's history. That's not what I asked. Did anyone check the county records before spending $85,000 building on that land? Diane looked at Carl Briggs. Carl Briggs looked at his hands. Robert Simmons told me later that the silence lasted approximately 8 seconds. In a room of 67 people, 8 seconds is a very long time. Patricia Howard spoke again. I want to make a motion. I move that the board provide a full public accounting of all community improvement assessment expenditures, with documentation, within 14 days. And I move that we formally request Diane Marsh's resignation as HOA president pending that accounting. Someone seconded it before she'd finished the sentence. The motion passed. 61 residents signed the resignation petition before the meeting adjourned. Diane did not resign that night, but walking home from the meeting, through the Clearwater Cove streets, past the lake access road, past the boat storage facility sitting dark on my land, she had to know that the authority she'd built over 6 years in this community was gone. Not because of me, because of what she'd done with it. The ground lease notices had been the pressure. The Attorney General complaint was the consequence. I want to be precise about the distinction because it matters. The ground lease review notices were leverage, legitimate leverage, grounded in documented breach, but leverage nonetheless. A tool designed to produce a response. To make clear to Diane and her board that the situation had moved beyond the realm of HOA disputes and into the realm of property law. The AG complaint wasn't leverage. It was a legal obligation. When you discover that a person has collected $179,424 from 89 families under false pretenses and spent $167,000 of it on herself and her allies, you don't use that as a negotiating chip. You report it, not because it benefits you strategically, though in this case it did, but because 89 families lost money they trusted a neighbor to manage, and that neighbor needs to answer for it. James filed the complaint with the Georgia Attorney General's Consumer Protection Division on October 1st. The filing was 47 pages. It included the complete HOA financial records, 3 years of income statements, bank statements, expenditure records, and vendor payment documentation. It included my analysis matching expenditure line items to specific residential addresses. It included the Georgia business record searches, showing that several vendors who'd received payments from the Community Improvement Fund couldn't be verified as legitimate operating businesses. And it included one exhibit that James had spent 2 weeks compiling, a side-by-side comparison of what the HOA told residents the Community Improvement Assessment would fund, the language from Diane's own HOA newsletters, versus what the money was actually spent on. Column A. Community-wide infrastructure improvements, road maintenance, common area beautification, shared amenity upgrades. Column B. Diane's landscaping, Diane's driveway, a dock for Diane, Sandra Cole's fence, Robert Nix's yard work, Gary Tillman's exterior renovation, cash withdrawals to unverifiable vendors. The gap between those two columns was $167,424. The AG's office acknowledged receipt within 3 business days. An investigator made contact with James on October 9th. What happened after that was out of my hands, by design. The AG's investigation was independent. I'd provided the documentation. I'd answered the investigator's questions about how I'd obtained the financial records and when I'd become aware of the discrepancies. Beyond that, the state of Georgia took it from there. I heard from Robert Simmons, my informal source inside the community, that Diane received a letter from the AG's office in mid-October. He didn't know the contents, but he said she drove to Savannah the following day to meet with Frank Delgado, and that when she came back, she looked like someone who'd been told something she couldn't unfold. The AG's determination came back on October 28th. I reviewed it carefully. The investigation had confirmed the core findings. $179,424 collected from 89 homeowners in Clearwater Cove between January 2022 and September 2025 under the designation of Community Improvement Assessment. The stated purpose, as represented to homeowners in HOA communications, was community-wide infrastructure and beautification. Actual community improvements funded $12,000. Mailbox cluster replacement, and 2 entrance benches. Remaining $167,424. Spent on improvements to Diane Marsh's property, $93,000. Improvements to properties of board members Cole, Nix, and Tillman, $57,900. And payments to vendors that the AG's forensic accountant could not verify as legitimate businesses, $16,524. The AG's office opened a formal criminal fraud investigation. Target: Diane Marsh, HOA President. Secondary subjects: Carl Briggs, Sandra Cole, Robert Nix, Gary Tillman. Board members who had voted to authorize the assessment structure and, in 3 cases, directly received funds. I learned about the real estate license separately. James found it during a routine background review he'd been compiling for the civil suit. Diane Marsh held an active Georgia real estate salesperson license. She'd been selling homes in Clearwater Cove and the surrounding Harmon County market as a side business since 2019, the same year she became HOA president. In that capacity, she'd sold 7 properties in Clearwater Cove over 6 years. 7 sales in a development where she controlled the HOA, managed the Community Improvement Fund, and, it now appeared, had been conducting unauthorized financial activity. James flagged it to the Georgia Real Estate Commission as part of a routine referral accompanying our AG complaint. The commission moved faster than I expected. On November 4th, Diane Marsh's real estate license was suspended pending the outcome of the AG's criminal investigation. Her response was to hire a new attorney. Frank Delgado, whatever his limitations, had apparently told her something she didn't want to hear. She replaced him with a litigator out of Atlanta named Stephen Ferris, a man with a reputation for aggressive defense of HOA boards in high-conflict property disputes. Ferris had won cases by overwhelming plaintiffs with motions, driving up legal costs, and pushing for settlements that minimized his client's exposure. It was a reasonable strategy against a plaintiff without resources or patience. It was a less reasonable strategy against a real estate attorney with 30 years of experience, a clean set of documented facts, and no particular urgency about timeline. On November 12th, James filed the civil suit in Harmon County Superior Court. 4 counts. Count 1, unauthorized construction on lessor property. The boat storage facility, $85,000 in replacement value, plus estimated removal costs of $23,000, plus damages for unpermitted construction on private property. Total claimed, $127,400. Count 2, unauthorized commercial use of lessor's private road. Lake access fees collected from 89 households at $400 per year from 2022 through 2025, plus the current year's partial collection, 3.5 years of unauthorized monetization of my private road. Total claimed, $142,000. Count 3, misappropriation damages. The $167,424 in community improvement funds spent on non-community purposes, plus legal fees associated with discovery and documentation, plus damages for the use of my land, the dock construction, the landscaping on parcels adjacent to my common areas, funded with those misappropriated fees. Total claimed, $198,000. Count 4, ground lease enforcement and declaratory relief. Formal judicial confirmation of Webb Land Trust's ownership rights, formal declaration of material breach by the 5 named defendants, and an order requiring immediate removal of all unauthorized structures from my property. Total civil demand, $467,400 plus attorney fees, costs, and such additional relief as the court deemed appropriate. Ferris filed Diane's response on December 3rd. It was, I'll give him credit, creatively constructed. He argued that Marcus Webb had purchased the Clearwater Cove development with full knowledge of the community's long-standing practices, that the ground lease structure, while technically valid, had been managed for 50 years with community governance taking practical precedence over the ground lessor's technical ownership rights. That Webb Land Trust had been a passive, absentee ground lessor who had allowed community norms to develop in his absence and could not now selectively enforce lease provisions he'd ignored for 4 years. And then he filed the countersuit. Hostile ground lessor, interference with established community rights, intentional infliction of emotional distress on a community leader acting in good faith, abuse of process, damages to the HOA and to Diane Marsh personally in excess of $300,000. The filing made the Harmon County Legal Notices section of the local paper. It also made, via a legal affairs blogger in Atlanta who covered Georgia property disputes, a brief appearance on a real estate law forum where practitioners exchanged notes on interesting cases. The summary was accurate. Ground lessor of a 340-acre development suing HOA president for unauthorized construction and misappropriation. HOA president countersuing for hostile interference with community rights. The comments on the forum post were not kind to Diane's legal theory. The hearing on preliminary motions was set for January 14, 2026. Judge Adrian Holloway, Harmon County Superior Court, 19 years on the bench, former civil litigator who, according to James, had a particular impatience for cases where the facts were obscured by legal theory. Ferris opened his argument on the countersuit with a 10-minute presentation about the history of community governance in planned developments, the social contract between HOA boards and residents, the implied authority of community associations, the equitable rights of long-standing community members in the face of aggressive property enforcement. Judge Holloway let him finish. Then she looked at the case file. Mr. Ferris, your client has filed a claim for hostile ground lessor interference with community rights. I've reviewed the plaintiff's documentation. The plaintiff owns all 340 acres of this development. His ownership is recorded, uncontested, and predates your client's board tenure by several years. She paused. What community rights specifically supersede fee simple land ownership? Ferris. Your Honor, the community has operated under established practices for decades. Established practices don't extinguish property rights. What legal theory are you relying on? Equitable estoppel, Your Honor. The plaintiff allowed these practices to develop. For 4 years, during which he was renovating his own home on the property. Equitable estoppel requires detrimental reliance on a representation. What representation did the plaintiff make that your client relied on? Ferris had an answer prepared for that. It was a long one. Judge Holloway did not appear to find it persuasive. She also asked at one point about the $167,000 in community funds. Ferris tried to steer away from it. The civil misappropriation claim was separate from the AG investigation, and he didn't want to argue both simultaneously. But the judge had read the complaint. Mr. Ferris, your client is countersuing a man who documented that she spent $93,000 of her neighbor's money on her own property. She's claiming he's the hostile party in this dispute? No clean answer. On January 21st, Judge Holloway dismissed Diane's countersuit in its entirety. The order was 7 pages. It methodically addressed each element of the countersuit and found each one either legally insufficient, factually unsupported, or both. The hostile ground lesser claim failed because documented material breach is not hostility, it's enforcement. The community rights claim failed because community governance authority derived from the ground lease could not supersede the ground lease itself. The emotional distress claim failed because filing a legally documented civil suit and AG complaint does not constitute intentional infliction of distress. The final paragraph was the one James read to me over the phone. Defendants' counterclaims appear to rest on the premise that community association authority constitutes an independent source of property rights, superseding the rights of the actual landowner. Georgia law recognizes no such premise. The motion to dismiss is granted in full. I was sitting on my porch when James called. The lake was quiet. The boat storage facility was still down at the water's edge. Its removal was part of the ongoing litigation, not yet resolved. But Diane's countersuit was gone, and the AG's criminal investigation was still open, and the civil suit was proceeding. "How's Diane taking it?" I asked. Ferris filed a notice of appeal within the hour. "She's not done fighting." "I know. She wasn't going to stop." I looked at the lake. "That's fine. Neither am I." The indictment came down on February 11th, 2026. I was in my kitchen when James called. Coffee going, lake visible through the back windows. The particular stillness of a February morning when the water is flat and the trees are bare, and everything looks like it's waiting for something. Diane Marsh was indicted this morning. Harmon County Grand Jury. 2 counts of criminal fraud, 1 count of breach of fiduciary duty, 1 count of theft by conversion. I set down my coffee. "What's the restitution figure?" $168,000. The AG pursued the full misappropriation amount. The grand jury agreed. Theft by conversion. It's a specific charge under Georgia law, when someone lawfully receives property on behalf of others and converts it to their own use. Diane had collected money from 89 families under the legal authority of her position as HOA president. She'd received it lawfully, in the sense that she had the authority to collect it. And then she'd spent it on herself. That's not mismanagement. That's not sloppy bookkeeping. That's not a board that lost track of the budget. That's theft. The civil judgment had come 3 weeks earlier, on January 22nd, 1 day after Judge Holloway dismissed the countersuit. James had moved quickly on summary judgment on the 2 clearest counts: unauthorized construction and unauthorized road fee collection. The documentation was unambiguous on both. The boat storage facility sat on my land without permits and without permission. The lake access fees had been collected for use of my private road and deposited into HOA accounts. Judge Holloway agreed. Partial summary judgment entered January 22nd. Unauthorized construction damages, $127,400. Road access fee restitution, $142,000. Subtotal before misappropriation claim, $269,400. The misappropriation count was folded into a consent judgment negotiated while the AG investigation was ongoing. The HOA's insurer, faced with the indictment and the AG findings, had stopped fighting and started settling. The consent judgment added $137,600, bringing the total civil judgment to $407,000 against the Clearwater Cove Community Association. The HOA's reserve fund held $94,000. Harmon County moved to seize it within 48 hours of the judgment being recorded. $94,000, gone immediately. 3 years of resident assessments collected for legitimate HOA operations. Road maintenance, insurance, administrative costs, seized to satisfy a judgment resulting from Diane's decisions. That left $313,000 of the civil judgment unpaid. The HOA had no assets to cover it. No insurance recovery. The insurer had settled their portion, not the full judgment. No reserve. No property. Which meant the judgment ran against the individuals who had authorized the violations. Diane Marsh, Carl Briggs, Sandra Cole, Robert Nix, Gary Tillman. Carl Briggs called James on February 3rd, before the indictment came down. He wanted to settle. He'd been on the board. He'd voted for the boat storage construction. He'd voted to authorize the community improvement assessments. But he hadn't personally received money. No payments had gone to his address in the expenditure records. He was culpable as a voting board member, not as a direct beneficiary. James negotiated his settlement at $31,000, contribution toward the civil judgment, full cooperation with the AG investigation, resignation from the board, and a signed statement confirming the authorization process for the boat storage facility and the assessment fund. That signed statement was useful. Sandra Cole settled 2 weeks later. Similar terms, $28,000, cooperation, resignation. Her landscaping payments were documented, $22,100, so her personal benefit was clear, but her role in the authorization process had been more passive than Diane's. James reflected that in the settlement terms. Robert Nix and Gary Tillman didn't settle. They hired their own attorneys and prepared to fight. I understood the calculation. Both of them had received direct financial benefits from the misappropriated funds, which meant their civil exposure was larger than Briggs's. Fighting felt like the lower-cost option. They were wrong about that, but they didn't know it yet. Which left Diane. Diane was facing the indictment. 2 counts of criminal fraud, 1 breach of fiduciary duty, 1 theft by conversion. Potential exposure under Georgia law. Up to 10 years on the fraud counts, up to 5 on the theft by conversion. She was facing $168,000 in criminal restitution. She was facing personal civil liability for the portion of the $407,000 judgment not covered by the HOA reserves or the settling board members. And on February 14th, 3 days after the indictment, she faced something else. Her mortgage lender called her loan. I want to explain the mechanics of this carefully because it's the piece of Diane's situation that most people don't fully understand when they first encounter it. Diane's home at 4 Clearwater Drive was a structure she owned. Under the ground lease structure, she owned the building, the colonial with the perfect garden, the driveway she'd had repaved with her neighbor's money, the yard she'd landscaped for $43,000 at community expense. But she didn't own the land. She leased it from Webb Land Trust. When the ground lease for her property was formally terminated, on February 12th, 1 day after the indictment, following the ground lease review process that had begun in September, she lost her leasehold interest in the land. What did that mean for her mortgage? It meant her lender's collateral had changed. A home's mortgage value is calculated on the total property, structure plus land. A bank lends against the combined value of what sits on the ground and the ground itself. When Diane had taken her mortgage, the lender had valued her property at $520,000, a well-maintained colonial on a lakeside development lot in Harmon County, Georgia. Without the ground lease, she owned a structure sitting on land she no longer had the legal right to occupy. The structure alone, no land, no lot, no leasehold, a building that would need to be relocated or demolished because its owner had no right to keep it where it stood, was worth approximately $180,000. Her outstanding mortgage balance was $387,000. Her lender's collateral had dropped from $520,000 to $180,000 overnight. The bank called the loan on February 14th. Diane had 90 days to satisfy it, or the lender would begin foreclosure proceedings on the structure. She didn't have $387,000. She didn't have anything close to it. What she had was a criminal indictment, $168,000 in criminal restitution, personal civil liability, a suspended real estate license, and a house she couldn't afford to keep on land she no longer had the right to occupy. She listed the structure for sale on February 19th. Asking price, $195,000. The same house that Harmon County tax records had valued at $520,000 8 months earlier. I was not the buyer. I want to be clear about that. The structure had to be removed from my land, or purchased by someone who would negotiate a new ground lease with me. Those were the two options for any buyer: a relocated structure or a new lease. I had no interest in purchasing Diane's house. She found a buyer in March, a family from Augusta willing to pay $185,000 for the structure, contingent on negotiating a standard ground lease with Webb Land Trust. James handled the lease negotiation, standard market terms, annual rent based on the assessed land value, 5-year renewal options, standard maintenance obligations. Diane received $185,000 for a home she'd purchased for $410,000 in 2016. After satisfying the mortgage, the bank accepted a short sale. She walked away with approximately $8,000. 9 years of home ownership in Clearwater Cove, the presidency of its HOA, 6 years of authority over the community, and she walked out with $8,000 and a criminal indictment. The media found the story in early February. I'm not sure exactly how it started. A legal affairs blogger who'd been following the Harmon County case, a post in a Georgia real estate forum, someone who knew James. But by the second week of February, the story was moving. The headline that got the most traction was straightforward enough to be almost funny. Georgia attorney moves into lake house. HOA calls 911, ends up owning their neighborhood. That wasn't quite accurate. I'd owned the neighborhood for 4 years before moving in, but it captured the shape of the story in a way that resonated. The coverage was national in scope by February 15th. Property law blogs, HOA watchdog sites, real estate forums. The story had every element that those communities found compelling. A ground lease structure most people don't understand, an HOA president who'd overstepped catastrophically, a ground lessor who documented everything methodically and enforced his rights through every available legal channel. The comments were voluminous. Most of them were some variation of, "This is why you read your closing documents." Among the 84 homeowners in Clearwater Cove, who had nothing to do with the fraud, families who'd paid their assessments in good faith, who'd trusted their board, who'd had $94,000 of their HOA reserves seized to satisfy a judgment they hadn't created. The coverage produced a specific, complicated emotion. Relief that the story was being told accurately, anger at what had been done to them, and a pragmatic urgency about what came next. They formed a community committee on February 8th, 3 weeks before the indictment, while the civil judgment was being processed and the AG investigation was still formally open. 12 residents, Patricia Howard, the retired accountant who'd asked the hard questions at the September meeting, was the organizing voice. They asked to meet with me. I said yes, immediately. The meeting was in the clubhouse on February 15th, the same room where I'd slid the financial records across the table at Diane 4 months earlier. This was different. Patricia had prepared a presentation, 12 pages. They'd reviewed the ground lease terms for every property in the development. They'd researched comparable developments in Georgia with ground lease structures. They'd drafted a proposal for a reformed HOA governance structure with financial transparency requirements, board term limits, and a formal lessor liaison process that would keep Webb Land Trust informed of any capital expenditure decisions. They were prepared, respectful, completely clear-eyed about what had happened and what needed to happen next. Patricia opened. "Mr. Webb, we want to be direct with you. The previous board created this situation. Most of us had no knowledge of the boat storage facility construction, no knowledge of the road fee collection, and no knowledge that the improvement assessments were being misappropriated. We're as much the victims of Diane Marsh's decisions as you are, more so, financially, because our reserves are gone." I listened. "We want to rebuild a functional relationship with you as ground lessor. We want to do it with full transparency, and we want to start by understanding exactly what our obligations are and what yours are, so there's no ambiguity going forward." I looked around the room. 12 people who'd shown up prepared, organized, and honest. 12 people who represented 84 households that had done nothing wrong. "That's exactly the conversation I wanted to have 4 years ago," I said. "I never had it because no one knew I was here. Let's start now." We met for 3 hours. Diane resigned as HOA president on February 17th. Not voluntarily in any meaningful sense. The resignation was the inevitable last formality of a collapse that had been in motion since September. The board had been reduced to 2 members, both of whom had settled their civil liability and were cooperating with the AG. The community committee had taken operational control, and the criminal indictment had made her position untenable in any practical sense. She submitted a one-paragraph letter to the remaining board members and the Harmon County HOA registry. She left Clearwater Cove on March 4th. I know the date because Robert Simmons texted me that morning. He'd seen the moving truck. Not two moving trucks. One, smaller than mine. It was gone by noon. I was on my porch when he sent the message. The lake was doing what the lake does in early March in Georgia. The water was still cold. The light was flat and gray, but there were the first suggestions of green in the tree line that meant spring was coming. I thought about my grandfather's 40 acres outside Valdosta, about the bank that called his loan in 1974, about my father's voice, matter of fact, telling me, "This is what the world does, and this is why you prepare." I'd prepared for 30 years. I'd built a legal practice and a land portfolio and a trust structure that held everything my family had lost and more. I'd purchased 340 acres of a lakeside development through 11 months of careful legal work. I'd renovated a lake house I'd been planning toward for a decade. I documented every violation with the precision of someone who knew that precision was the difference between justice and frustration. And on a Saturday morning in September 2025, a woman in a pale blue bathrobe had called 911 on me in my own driveway. 5 months later, she was gone. The 84 homeowners who remained were my neighbors now, genuine ones. Patricia Howard's committee had begun the work of rebuilding the HOA, with the transparency and governance structure it had always needed. The boat storage facility would be removed in the spring, when the ground was dry enough for the demolition crew to work. The lake access road was being formally documented in a new community agreement that acknowledged Webb Land Trust's ownership while establishing clear, fair access terms. Things were, for the first time in 4 years, as they were supposed to be. I went inside and made breakfast. The lake outside my window was quiet and cold and entirely, perfectly mine. 6 months is enough time for a place to become itself again. By March, the Clearwater Cove Community Association had been formally reconstituted. New bylaws, new board, new financial controls requiring dual signatures on any expenditure above $500, quarterly statements distributed to all 84 households, and a standing lesser liaison committee responsible for maintaining communication with Webb Land Trust on any capital project that touched common areas or ground lease parcels. Patricia Howard was the new president. She'd run unopposed. The new ground lease agreements had taken James and me 6 weeks to draft, not because they were complicated in principle, but because we wanted them to be right, clear, specific, written in language that a homeowner reading their closing documents in 2035 would understand without needing a real estate attorney to explain the structure to them. What did the homeowner own? The structure, the building, the improvements, the personal property within. What did Webb Land Trust own? The land, the 340 acres, the roads, the lake access corridor, the common area parcels. What was the homeowner's right? To occupy their lot under the lease terms, to use the common areas under the community agreement, to access the lake via the licensed use agreement for the private road. What were the terms? Annual ground rent at 2.1% of assessed land value, 5-year renewal options with capped rent escalation, clear maintenance obligations on both sides, and an explicit provision that no permanent structure could be built on lesser property without written authorization. That last clause was new, not to the legal principle, it had always been true, but now it was stated plainly, in a paragraph that couldn't be overlooked, in a document that every homeowner signed. The boat storage facility came down on March 18th. I'd hired a demolition crew out of Macon, 4 days of work. The concrete pad took the longest. It had been well poured, which was, I noted with some dark appreciation, a testament to the quality of construction the HOA had funded with the money they'd taken from me and their neighbors. The rebar ran deep, but by day 4, the land at the bottom of the lake access road was clear. By April, there was grass growing where the concrete had been. I'd thought about what to put in its place. A covered picnic area, open to all residents under the community agreement. 6 tables, a small fire pit, a clear view of the lake. Nothing elaborate, just a use of the land that served the community it had been taken from. The groundbreaking was April 29th. Patricia brought the whole committee. Someone brought lemonade. The property values had recovered faster than I'd expected. In the immediate aftermath of the civil judgment and the indictment, several homeowners had listed their properties in what felt like panic. The combination of seized HOA reserves, uncertain ground lease status, and media coverage had spooked a handful of people into wanting out. Those sales had gone low, but by April, the pattern had reversed. What buyers were finding in Clearwater Cove was something that had genuine market value: clarity. The ground lease terms were now written in plain language. The lessor was known, local, accessible. The HOA governance was transparent and documented. There was no comfortable ambiguity, but there was also no risk of discovering 4 years in that your HOA president had been spending your assessment fees on her driveway. Real estate agents in Harmon County started using a phrase that I heard from 3 different people in the span of 2 weeks: the cleanest title situation in the county. By June, the median sale price in Clearwater Cove had returned to within 7% of pre-litigation levels. By August, it had exceeded them. James drove down from Atlanta on the first Saturday in September. 1 year, almost to the day, from the morning Diane Marsh had called 911 from her porch. I'd been on the dock since 6 a.m. The September light in Georgia does something particular to lake water, flattens it to a kind of hammered silver, makes the whole surface look like it's been worked by hand. I'd been fishing without much intention of catching anything, which is the best way to fish when what you actually want is to sit on your own dock and let a year settle through you. James's car pulled up the driveway at 9. He came around the side of the house, through the back gate, out onto the dock. He was dressed like someone who'd driven down from Atlanta on a Saturday morning, pressed but relaxed, carrying a coffee cup he'd picked up somewhere on I-75. He stood beside me for a moment, looking at the lake. "Nice," he said. "Yes." He pulled up one of the dock chairs and sat. He'd been my law partner for 16 years. We'd shared more difficult conversations than I could count. He knew when to let silence go its full length. We sat for a while. "Was it worth it?" he asked eventually. "The whole thing. The 911 call, the legal battle, the move to rural Georgia. All of it." I thought about how to answer that. "Diane called 911 on me in my own driveway," I said, "in Georgia, as a black man." I kept my eyes on the water. You think I was going to let that go without making sure she understood exactly whose land she was standing on? James was quiet. "That's fair," he said. "But some people, the coverage afterward, some of the comments, some people said the ground lease enforcement was heavy-handed, that you had other options. She built a permanent structure on my land without my permission. She collected $106,000 in fees for access to my private road. She embezzled $168,000 from her neighbors." I set down the fishing rod. There's nothing heavy-handed about enforcing contracts that were in place before either of us was born. The ground lease existed in 1968. It was there when Diane bought her house. It was there when she ran for HOA president. It was there every single year she was collecting her neighbor's money. She didn't find the limits of my patience. She found the limits of the law. A heron moved across the far end of the lake in a long, slow glide. "Robert Nix and Tillman?" James asked. "Their trial's set for February. Ferris dropped them. Conflict of interest once they were separately named. They've got new counsel. They'll settle before it gets there. Probably." The water was completely still. I thought about something my father had said once, not in the context of land or law or any particular circumstance, but in the specific way he said things that were meant to carry forward, the way he spoke when he was telling you something to keep. He'd said, "The people who take from you are counting on you not knowing what you have." I'd known what I had. I'd known it for 30 years. I'd built toward it for 30 years. Every case I'd filed, every deed I'd reviewed, every title search I'd commissioned, every closing document I'd read to the end, all of it was preparation for the version of the world where someone assumed I didn't know what I had. Diane Marsh had made that assumption on a Saturday morning in September, with a phone call to the sheriff's department. "My family lost their land in Georgia 50 years ago," I said. "Not because they did anything wrong, because they didn't have the documents, didn't have the attorneys, and didn't have the knowledge to fight back when the bank called their loan and the system looked the other way." I picked up the fishing rod again. I spent 30 years making sure I'd never be in that position, that I'd always have the deed, always have the trust structure, always have the documentation to stand in my own driveway and hand a deputy the master deed to everything around him. I looked at James. Diane Marsh found out what that preparation looks like. So did every deputy who showed up at my driveway that September morning. So did Frank Delgado and Stephen Ferris, and every judge who reviewed this case. I paused. And so did every homeowner in this development who signed a new ground lease this spring and understood, maybe for the first time, exactly what they owned and who owned the land beneath them. James looked out at the lake. Your grandfather would have appreciated the outcome, he said. He would have appreciated the dock. James laughed. The sound went across the water and came back to us. We fished until noon, nothing worth keeping. The lake was cold and clear and completely, perfectly mine, the way it had always been.